Welcome back, folks. We're going to turn now to Massachusetts for the surgeon strangles wife murder case of Ingolf Tuerk. Now, Tuerk is charged with killing his wife, Kathleen back in 2020. Tuerk actually confessed to the killing and led investigators to the 45-year-old woman's remains in a pond near their home. And the well-known robotic surgeon, whose skills were perfected in East Germany, secured his immigration to the United States to teach American doctors the techniques. He also claims to have been a former East German Olympian. Let's take a look together back at this case before we go into the motions hearing, where the defense is seeking the victim's medical records and is requesting a change of venue.
Dr. Ingolf Tuerk is not your typical surgeon. At 6'3" with an athletic physique, it's easy to see why he was once a member of the German Olympic decathlon team.
This ad from Steward Healthcare focused on the once prominent urologist, Ingolf Tuerk.
Surgery is physical, very demanding work. For hours, you are physically involved in a surgery, and that requires that you're physically fit as a surgeon.
Tuerk's face was featured on billboards across Boston, but after being charged with medical billing fraud, the doctor's career spiraled, and his personal life took a dramatic turn when he was arrested in connection to the death of his wife, 45-year-old Kathleen McLean.
We agree to the motion for disclosure of bad acts, if there are any intended, as well as defendant's conduct.
Ingolf Tuerk was called Harry by his wife, Kathleen. The two met online in November of 2017, and 4 months later, they were engaged and living together with Kathleen's 3 kids. At first, they seemed to live a life of domestic bliss, but that would all change.
Kate McLean painting the picture that the district attorney's office has been painting, that she was a victim of domestic violence, being married to this guy, that he was abusive, that he was controlling. She ended up getting restraining orders.
Kathleen told police she was physically abused and wanted a divorce back in February of 2020, but the couple then reconciled. On May 15th, after Kathleen's friend received a text from Tuerk saying, "Kurt, I am sorry, brother, but she is a vindictive devil. She played us all. I'm really sorry, brother, but she manipulated us all. Love you, Harry." Police were alerted and began their search for both Harry and Kathleen. Harry was found unresponsive with cut wounds to his left wrist and a laceration on his forehead. He awoke in a hospital the next day and told police he choked Katie to death after an altercation where she struck him in the head. He then dumped the body in a nearby pond.
He admitted to the fact that in the course of hot blood, heat of passion, at the worst, is that they ended up with a physical confrontation between the two of them, and she ended up dead. That's right.
So what does that get him off the hook for murder?
That's up to a jury.
All right, let's go now to that motions hearing. It took place last week. The first arguments are regarding a motion brought by the Commonwealth seeking protective orders for certain information gleaned from phone searches and similar searches. Let's go into court for that hearing.
Is a Commonwealth's motion for protective order for report 1 of the independent examiner?
Yes, Your Honor.
Can you tell me what that is?
Your Honor, I think we had talked about previously that the Commonwealth had retained Mr. Sack to do an independent review. So he's filed an initial report, and we'd like to redact a couple of areas which are mentioned in that protective order, and then Mr. Reddington has signed the motion, and then we'll provide that report to Mr. Reddington today.
So there's no objection? Mr. Reddington? So I'll allow it by agreement?
Thank you.
Then there was a second motion, similar title, Commonwealth's motion for protective order, reports as to search of work phone and associated iCloud account.
So I have my own independent duty separate from Mr. Sack, and so that protective order is relating to the inquiry and search that I have done personally with regard to that phone.
Okay. The same phone, however. Is that right?
Yes, it's the same extraction, or it's a similar extraction, same phone, just by 2 different entities.
And Mr. Reddington, no objection?
No, Your Honor. I've been working with the DA on this. I'm aware of what's been going on with it.
All right, so those have both been allowed by agreement.
Thank you.
I didn't have a motion. I think the first part of this was heard some time ago in front of one of my colleagues. Motion for medical records of Kathleen McLean. Did you file that, Mr. Reddington?
I did.
Okay, and my understanding was that there was never action taken on it.
That's correct.
All right, Judge, pretty straightforward there. There's some information contained in a report. Not exactly sure what the report is, but something that was reviewed by an expert. Also some phone extractions that they want redacted because whatever information might be protected or privileged for whatever reason. And both sides seem to be very cooperative.
Yeah, it is nice to see at this stage in the game. You don't fight about things unless you have grounds to fight.
Yeah, I agree. So, look, that's a nice way to begin this particular hearing. We'll take a break, though. Still ahead, breast enhancement surgery is really at the center of a motion by the defense in the murder case against Ingolf Tuerk, and the Commonwealth is accusing them of trying to shame the victim. Keep it here on Court TV Live. We'll be back in a moment.
Belong to something greater.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We are continuing our coverage of a motions hearing in the surgeon strangles wife murder trial of Ingolf Tuerk. Tuerk is accused of killing his wife, Kathleen McLean, and then dumping her body in a pond in May of 2020, right at the start of the pandemic. Investigators say her body was weighted down with rocks in her pants.
Last week, Tuerk was back in court ahead of his trial, which is scheduled for next month. His attorney argued a motion to obtain the medical records of the victim concerning her breast enhancement surgery. But the Commonwealth accused the defense of trying to objectify and shame the victim. Let's listen to both sides of the argument.
Do you want to argue that now? And
Just, I think the motion pretty much speaks for itself, Your Honor. It goes to the same thing that has been, repeated, that Ms. McLean was providing significant amount of money to improve the property she was taken advantage of, allegedly by Harry, that she was providing a lot of money for them to work in the backyard. She didn't provide literally a nickel to work in the backyard. The only money that he provided to her was for breast enhancement surgery. I have filed a Rule 17 requesting that we have access to the medical records, and that's what's before you. I have spoken with the doctor who performed the surgery. Needless to say, there's some HIPAA issues that would preclude him from being specific with me, but my investigation has revealed that, in fact, Mr. Tuerk paid for the surgery. That was the only check that was given to him. It was $60,000, a significant amount of money to reimburse for the surgery. I think that's relevant material. I've requested that it be allowed, and we can circumvent the HIPAA law by providing evidence regarding that issue.
And your argument as to relevancy?
It's the same thing I've argued before, Your Honor, before you, where you have on one side the theory that this abusive individual was married, living with her, that he was precluding her from having access to her friends, he was precluding her from working, he was precluding her from having her own car, which in fact it wasn't her car, it was husband number two's car, and he's the one that wanted it back, that she was precluding him, meaning Mr. Tuerk, from, basically he was preventing her from living a life and socializing with people, which we all know is typical of an abusive relationship. When you talk about the cycle of violence, that's the thing, that's the theory. I have the right, I would argue, to rebut that and to show that, in fact, no, he did not prevent her from accessing her friends. He did not prevent her from having access to a motor vehicle. If anything, he provided a motor vehicle for her. Same thing with this. She did not provide money to fix his house. It was his house that he purchased. It was his house that he was living in. She moved in with him with her 3 kids And for 2 years, they lived in that house. He supported them. She ended up for 6 months paying $1,000 a month for food, to help out with the 3 kids for their food, for expenses that were incurred in running that house. Then they get married. And now we run into 2020, and prior to that was the surgery. And the surgery, I think, is not to embarrass, it's not to humiliate, it's just really simple. It's the only money that she ended up borrowing, if you will, off of him, that he ended up paying for that surgery, and she ended up paying him back as best she could. So that's the relevance of it, because I have a right to show, because as I said before, I know that the government wants to just put this under a microscope and limit it and say, okay, we're starting off with week number, whatever it may be, and then we're going forward for that following week, and she was abused, she was beaten, she was strangled, she was killed, put in the pond with the boulders, and that's the case. Well, that's not the case. I have a right to show the nature of the relationship, a right to show the fact that all the way through that relationship that there was insinuation that she wanted him to come back. She would weaponize, as I said to you before, the system in the sense of the 209As, just as she did with the other husbands. When she wanted something and she got into a probate battle, if she wanted something, she would weaponize the system, get a 209A, get a restraining order, charge them with criminal complaints, and then null-cross them, not cooperate with the DA, dismiss them. That's a pattern of conduct. The pattern continued in this case, where she ended up taking out charges against him, got him thrown out of the house, and the reason is because she went on his phone and she saw an email from a woman that he hired as an attorney to handle the divorce 6 weeks or whatever it is after they get married. They were only married for a short period of time. So all of these things go to show the nature of the relationship. I can't think of the number of times that a man is charged with a homicide of his wife, and the McRae case and all the rest of the cases that are cited to the court. Oh my goodness, we're entitled to show the nature of the relationship. The government is entitled to show the fact that this person was doing something to minimize the worth of that woman, that she was being prevented from seeing her friends. All of the stuff that would be introduced to show a jury that this was an abusive, classic relationship. Flipping it on the other side, here's a man who was ended up where he was taken advantage of. He was duped into signing a deed to have her on the property. He was duped into signing a post-nup agreement. So all of these things taken individually, where they say, well, you know, sign the deed, who cares? Post-nup, who cares? But when you take them all together, and you can see that she's telling him, which will be the evidence, that they're going to reconcile. She's telling other people that they're going to reconcile. She's telling other people that she wants to be able to make the marriage work, but yet she's acting with other men in a fashion that belies that. So all of these aspects come into play in proving and showing the nature of the relationship, which I might also add, towards the end, was at the height of the pandemic. He had been thrown out of his house. He was living in Florida. He had a friend that had a trailer that allowed him to live in his trailer. Then when he came back up, when it looked as though they might be able to reconcile, and he stayed in the hotel, that there was no intent on her part to reconcile at all, culminating at the time of the actual killing in the course of the argument, when she smashed the rocks glass on his head and told him basically that she had never had any intent that they would get back together again. I've got emails that will show his state of mind, and government has them, they got all the stuff off of his phones, to people, saying to people how terrified he was of dying from disease, dying from the pandemic, because he had no way to live. We all remember what that was like as we hid in our homes and were afraid to go into a supermarket. You had the arrows on the road, you had to walk in a certain direction with masks on. He had an extreme fear of losing his life during that pandemic. All of this goes into his state of mind at the time of the incident, which deals with the issue of hot blood, heat of passion, and whether or not there's any intent to kill.
If this was a motion to show a financial arrangement, it wouldn't have been a motion for privileged medical records about a woman's elective surgery. It should have been a motion for the defendant's bank account to show that he wrote a check for $30,000 and then somewhere along the line the victim paid him back. That's not what this motion is. This motion is a broad motion for medical records about a woman's personal decision to have an elective surgery. And this court, I would suggest, should not consider this motion in a vacuum or one-off. It goes to the pattern of the motions that were filed this summer and this fall, where the defendant made many statements and allegations about the victim's conduct and her sexuality. These records are highly inflammatory. They just serve to objectify this woman and shame her for an elective surgery that she had every right to have. It's not relevant to an issue in this case. The financial arrangement is besides the point. Again, financial arrangement is not an issue to this case, but if this was actually a motion for financial records, I would suggest the defendant has the means to get it from his bank account, which goes to that fourth prong, that he can acquire that information elsewhere. And so, Your Honor, I would ask that this motion be denied.
It's an interesting argument, Judge. Are you buying this idea that this request by the defense, and clearly they have some ulterior motives for wanting it, but do you think it's about shaming the victim? Does that shame a woman when they're going to get breast enhancement surgery?
Well, I think the reality is whether or not it does, it could be relevant to this case. I don't think that's the only reason they're requesting it. I do think it's a huge amount of money, a big sum of money, that it is fair to say we do want that.
Yeah, fair
All
enough.
right. All right, the judge did not make a ruling on that motion, but did say he would take it under advisement.
All right, we need to take a break, folks. When we come back, we'll hear from the defense regarding their motion for a change of venue. They say pretrial publicity has tainted the jury pool by painting the defendant as a beast who abused the victim. Keep it here on Court TV Live.
It was the biggest story in the world.
People saw the facts differently.
Somebody manufactured evidence in this case.
This was kind of a crazy spectacle.
This case is a circus.
He was an icon.
They are in for the fight of their lives.
Everybody thinks you're guilty. Trial and Error. Why did O.J. win? New episode Sunday night, 8 Eastern and Pacific, only on Court TV.
Back now to Massachusetts for the motion hearing of Ingolf Tuerk. Tuerk was a well-known Massachusetts robotic surgeon who was fired after a bullying scandal. Prosecutors say he killed his wife and left her body in a pond near their home.
Now, last week, Tuerk was in court for a motion hearing, and we're getting caught up on that. Let's listen now to Tuerk's defense arguing a motion for a change of venue. Let's get back inside that courtroom.
I know from your experience as a very experienced prosecutor and now obviously as a judge, you're well familiar with 37B1, giving the court discretion to determine that a person is not able to get a fair trial based on pretrial publicity within a particular county, and if that's the case, then the matter would be referred to a contiguous county. In this motion, I'm requesting that it be sent to Suffolk, Your Honor. I have cited, obviously, the lead case of Murphy versus Florida. Then I cited the lead case in Massachusetts, if you will, which is Thomas Toolin, which, as I indicated in the motion, I represented Mr. Toolin, who was down in Nantucket on a murder case. Significant publicity as well. The motion for change of venue was denied, and the Supreme Judicial Court reversed it, saying that, in fact, there should have been a change of venue. But on the other hand, I also commend, if you will, to the court's knowledge as a judge and as a trial counsel prior to that. I'm well aware of the fact, and I'm sure the government's going to argue, that we could inquire individual voir dire with potential jurors as to whether they read or heard or know or think anything about the case. So without belaboring each and every point of law, as well as coupled with what I've added as the pretrial publicity, the Boston Magazine article, a number of other newspaper articles, I will point out, Your Honor, that of late, recently, the new thing now is the YouTube. And Your Honor, I'm sure is aware with the Karen Reed case that there are a lot of YouTube people. They get into the sensational aspects of the trial and they pick it apart and they have a lot of people that sign on and they listen to it and debate it and talk about it, which is fine. There's one individual who I think has some credibility, and she seems to be very intelligent and is somewhat fair in her observations. Melanie Little is her name, an attorney from New York. And then there's a lot of other people that are more salacious and into talking about the emotions of a case, if you will. So I think that's, and she has not one, not two, but three Dr. Tuerk segments, if you will, where she's talked about the case and has taken on the position of the victim. She went through the typical abuse, if you will. Again, the things we were talking about, hiding, pushing, preventing them from having access to their friends, even though there's emails where she doesn't like her family, she had a lot of issues with her family. The government is not able to just maintain the fact that this is a person who's just which is the picture that's painted, and I know you read all the stuff I attached, that she's just a happy-go-lucky woman who would bake cookies and leave them on the neighbor's porch steps, and everybody loved her, and she's a Reiki master. It's all smoke and mirrors. No, it's not. And I have a right to show that, but as far as a jury is concerned, I think that a change of venue would be appropriate for any number of reasons, not the least of which is logistics as far as trying this case in the time frame that we're dealing with the other case that's going to be going on trial at the same time. So when you add all of that together, I think the impact on a jury, because we all know, and I know we're supposed to assume that jurors listen to judges when they instruct, and I know, and I've heard your instructions, you're very forceful. You tell the jury you cannot go online, you cannot go on the internet, you cannot read anything, look at anything. I think, honestly, they do anyway. I think probably there's going to be a lot of potential jurors that are going to be aware of this case and the allegations. And the allegations are just all shifted towards the side of her being an abused woman, ultimately being murdered by this beast. That's where the government's theory is, and that's what the news media has been portraying, which is as far from the truth as possible. So I do think, respecting and understanding that the court has the ability to inquire of jurors, I do think that a change of venue would be appropriate.
Thank you, Your Honor. As Your Honor knows, the change of venue is only ordered with great caution and after defendant has established a solid foundation of fact. The defendant has to show the coverage was extensive, it was sensational, and that this court cannot impanel an impartial jury in Norfolk County. I would suggest the defendant's filing does not meet any of those standards. 14 articles were attached spanning over 4.5 years of this case. Looking at those articles, they're just clustered around 2020 when the events initially happened, and a few articles in August and May of 2024. And significantly, those articles of August and May 2024 are factual recountings of what's going on in the courtroom. It's quoting the defendant's counsel, making arguments about the defendant's statement of the case. It is not all about the Commonwealth's case. There is no sensational reporting in those facts. I would suggest that the case Commonwealth v. Bateman, 492 Mass 404, that's cited in the Commonwealth's opposition, provides a pretty clear analogous situation where defendants submitted a computer search of archived articles, didn't say how many people viewed that article, and it was 58 articles over a 2-year span, and it was in a county of 700,000 people. And the FJC affirmed that that showing was not sufficient to warrant a new change of venue. And I would say here that we have even less of a showing. The YouTube segments that counsel referred to today were not submitted. I have not seen them, but again, YouTube, that goes worldwide. There's no showing that Norfolk County has been so saturated that this court cannot choose an impartial jury out of a pool. Commonwealth submitted the statistics that there are 580,000 people of eligible age to serve on a jury. There's a large pool here. Court defendant has not made any showing that this case has been so extensive that we can't employ the normal practices of an individual voir dire and instructions such that we can get an impartial jury. I would also suggest where the defendant is asking that this be moved to Suffolk County. Well, the defendant was a world-renowned urologist in Suffolk County. It's contiguous to Norfolk County. If it's impartial here, there's saturation here. Defendant hasn't explained how that hasn't moved over to Suffolk County, where he was the world-renowned urologist that he claims he was. The defendant has not made a sufficient showing on all three prongs, and the motion should be denied.
Thank you. I will take that under advisement as well. Motions in limine are going to be filed on both sides, I take it?
Yes, Your Honor. We've been working through some of the issues as well. I can tell the court out of court, for example, regarding lab witnesses, redactions to the defendant's statement, a proposed transcript for the jurors. I don't remember whether we talked about this or not, but it's an audio statement only.
Of the defendant.
Of the defendant. It's difficult to hear because everyone's wearing masks. But I think we talked about the counsel coming to look at the physical evidence, which the Commonwealth intends to introduce. So I think we're working through many of the issues that will be addressed in motions in limine. I also wanted to point out for the purposes of the record that the Commonwealth had a motion for Norwood Hospital records of the defendant that was allowed. Obtaining those records has been a little bit challenging because of Steward's demise. So we recently were able to connect with a human being who might be able to get us the medical records after we attested that we weren't going to be using the medical records to prosecute anybody for reproductive health issues. So we've done that, and we're hopeful that we'll get those medical records. The only other thing that I wanted to make sure that we addressed is that we do plan to file a motion for review. There'd be 3 locations that we would suggest would be appropriate to travel to in this case. 1 in Dedham, certainly not far from here, and the 2 in Dover that are not far from one another.
Mr. Reddington, what's your position on the view? Any objection to that?
No, I agree with that, Your Honor. I think that that would be helpful to the potential jury, and I have spoken with Mr. Tuerk, Dr. Tuerk, and he would not be present at the view.
Okay, so we can talk about coordinating the time for that as we get into empanelment?
Yes. The only other thing that we were asking the court to endorse today is a judicial order for the Department of Children and Families. I don't know that we're going to be calling anyone from there, but in order to meet with them and in order to make that determination, we just need that judicial order signed, and I don't think the defense has any objection to it.
No objection?
No, okay.
All right, so I'll endorse that as well. All right, other than the motions in limine, what else is left?
I don't know of anything from the Commonwealth's perspective.
I don't know if Your Honor would consider, if we should file a written motion, if this flag the issue, if you consider perhaps extra challenges.
Extra challenges? Why don't you file a written motion, and I'll take a look at it.
Yep, that's fine. Has there been any logistical decision on the courtroom that we're actually going to be in? My understanding is that we would have been in the courtroom right here. That's what Your Honor's understanding is.
Meaning the big courtroom?
The big courtroom.
That is my understanding.
Excellent. Great.
Chief Rose, is that your understanding? It's never good when he walks like this up the side. All right. I'll nail that down in the next couple of days. But you have no objection to the setup of the jury box in that?
No, I've waived that. Actually, with present counsel, I've waived that and said that it's one of my favorite courtrooms. I think it's a great courtroom to try a case in.
All right. We'll nail that down in the next couple of days.
Thank you.
The impanelment is set for Tuesday, the 25th?
Yep.
Okay. As of right now, I am going to be out the 3rd and the 4th of April for a judicial conference. I'm trying to see if I can be here the 3rd. I'll know that in the next week or two. But just to give you the heads up now.
We don't want to interfere with the judicial conference, Judge, so the 3rd's fine.
Tuerk is set to be back in court on March 11th for another hearing regarding evidence ahead of his March 25th trial.